Whitney, we're so honored to have you with us today. Welcome to Constituting America's Constitutional Chats. We're going to ask you to share a few opening comments about how the Supreme Court works. And with all your experience, we can't think of a better guest than you. And then we'll go to questions. So I'm going to turn it over to you.
Well, thank you, Kathy, and everyone so much for having me on the show. It's a privilege to be here. I've been following the work of your organization for some years now, and would have loved to have taken part in it when I was, in high school and college. So thank you so much. So I never thought in a million years I'd have the honor of clerking for, one Supreme Court justice, let alone three. So sometimes I have to pinch myself about the things that I've been able to see and experience. But I know I'm here to talk about how the Supreme Court works, kind of a high-level overview of some of the nuts and bolts of what it's like to be a law clerk and to be in the building. So I think the easiest way to think about the Supreme Court's work is to think about the life cycle of a typical case as it's coming up from the lower courts. So the Supreme Court has jurisdiction to hear cases involving federal law. That means it can hear cases coming from the state courts or the federal courts, so long as there's an issue of federal law at play. And it primarily does that through what you'll hear is called, it's the petitions for writ for certiorari, meaning that someone asks the court to choose to hear the case. That means the Supreme Court is primarily a court of discretionary review. It has the option to choose its cases. That's a bit different from the federal courts of appeals, which pretty much take the cases that come to them. So it's really hard to get your case heard by the Supreme Court. In any typical term, there's about 7,000 petitions, and the court might grant anywhere around 60 to 70. So we're talking about a very small percentage of cases that come before the court. I should also mention that there are two other ways that the court can hear appeals involving election law cases, which come to the court in a different way and is then a petition for writ for certiorari. There's also rare instances where states can sue in the Supreme Court directly, sue another state, and the Supreme Court operates as a trial court. So, but those are a small sliver. Let's stay focused on the petition. So you convince the court to hear your case. How do you do that? You have to get 4 justices to agree to vote to hear the case. Now, the justices have, as I mentioned, thousands of petitions coming at them. How do they cull through all of those? There's a process known as the cert pool, where the law clerks, so around 30 to 40 law clerks per year, will get together and divide up all the petitions coming in the door and write one memo that goes around to all of the justices. So if you are, nervous turning in your first English paper in high school, imagine how you would feel as a law clerk turning in your first memo that's going to, 9 Supreme Court justices. It's pretty nerve-wracking, but we have examples and training on how to do that. So the justices will receive those memos that discuss the case, whether it might be a good case for the court to take. And what we're looking for there are cases involving situations where the lower courts have disagreed about an important legal issue. And it's generally the case that the court doesn't want there to be one rule of constitutional law in California that applies differently in Florida. So the court will often take cases to kind of clear up any disagreements in the lower courts. There's also cases that are we would think of as important, even if there's no disagreement. If an important federal law gets struck down as unconstitutional, that might be a case that the court would be inclined to take. So those are some examples of what the court's looking for. The court then meets with only the 9 justices in a room called the conference room, and they have conference. This is a very secretive meeting. No one else is allowed. The junior justice sits close to the door and has to answer the door and pass notes, things like that. So the justices deliberate on what cases to take, and they end up, deciding to take cases. From there, we're moving to the next step, which is preparing for oral argument. This is what we often think of when we think of court. The law clerks and the justices will work to prepare memorandas to each other about the case, how the law clerks might think it needs to be decided or what the proper answer is, and will perform research that the justice asked them to perform in preparation for the oral argument. Some justices, have different approaches to oral argument. It's wonderful now we get to hear questions from all 9 justices, including Justice Thomas, who had not historically asked many questions. Some justices are known to practice their questions on law clerks walking around the building or on their own law clerks, which can be daunting if you're on the other end of a question from, Justice Alito. It can be a nerve-wracking situation, but the arguments are heard in the months of October through April, and the court will hear about anywhere from 12 to 15 arguments or so each month. And the oral advocates get up, they argue for about 30 minutes per side, although that's been stretching, and the justices ask questions. After that, the justices meet in another conference and they vote on how the cases are going to be decided. This is a very important thing for justices to be listening to other justices' reasonings about how they think the case should be decided. Because it could be that everyone agrees on the outcome, but people have very different ways of getting there as a matter of legal analysis. So everyone is taking notes, thinking about the case and talking about the case, how they think it should be resolved. After that, the senior justice in the majority, so the chief justice, if he is in the majority, or then the next most senior justice in the majority, has the right to assign each opinion to the writing justice. So after a conference, there will be both a resolution of the case and an opinion assignment. Those come around at the end of a sitting on a Friday afternoon and hard coffee, and all of the clerks, huddle around the mailbox and wait for that opinion assignment to come through to see if your justice was assigned the opinion, you wanted. So after that, we're moving into the opinion drafting stage, where the justice working with his or her law clerks will come up with a first draft of the majority opinion. Again, implementing the reasoning that the justice, wants to employ, but also trying to craft an opinion that is going to reflect the reasoning of the justice's colleagues as well, because you need to get 5 justices for that opinion to be a majority opinion and to be the controlling law of the land. So that is a very iterative process, goes back and forth. It's also, so then that opinion will circulate around to the other justices and they will decide to join or not join or ask for edits in order to join. Then there will be potentially separate writings, a dissent or a concurrence. All of that is flying around. There's a lot of paper going around, but at the end of the day, that will come out in a final opinion for the court that is released by the judge. They're back to reading their opinions from the bench on what are called hand-down days. So the court will announce that the justices are going to announce opinions, and the justice in the majority who has authored the opinion will read the disposition of the case from the bench, as well as some brief detail of the reasoning. So that's pretty much the soup to nuts from the start to finish. There's also a whole bucket of miscellaneous emergency cases that come to the court that we can talk about later. But as a general matter, that's the life cycle of how the court is going to adjudicate the cases that comes before it.
Well, that's great. Thank you so much. That was a really enlightening overview. And I know I learned a lot just now, and I'm sure our audience did too. And Janine, I'm going to toss it over to you.
Thank you. So wonderful that you're here with us today and have all this experience and knowledge. All righty. Well, I think my first, we're talking about justice in this series, American justice. So how do you think the Supreme Court fits in to making sure that America is just?
So when you walk in front of the Supreme Court, inscribed on the front of the building says equal justice under law. And I do think each of the justices take that to heart. And as I mentioned, part of the role of the Supreme Court is to supervise what is happening in the lower courts and to make sure that the Constitution and the statutory laws are being followed by private parties, by governments, and by the lower courts. So by exercising that authority to correct the law if it's being misapplied, and to step in if there is a situation where a legal wrong is playing out in a way that harms, a party, the court absolutely has a role in rectifying that situation. It also has an important limit on its power, which is to interpret the laws and not to make the laws. And by that, I mean, it's important for justice and for people, citizens fulfilling out democracy principles to understand that they have the final say on many of these issues through the legislative process. And so it's equally important for justice from that perspective that the court is able to stay in its proper role as the judiciary and interpreting the laws instead of exercising kind of the legislative power.
And so there's justice for people, but through the states, of course, right? But since it's federal, it can deal with either the states against the states, or if a person's dealing with a federal issue, like a right of some sort, correct?
That's right.
Right. So talk about the justice, because since it's about justice, what about the cases that can't get there, that don't make it?
That's right. So there are many cases that do not get heard by the court. And in our system, that is why the founders thought it was very important that state courts were able to equally decide federal constitutional issues, and also that there is a very rigorous process for appointing and confirming the lower federal judges. Because at the end of the day, you're right, there are many cases that the Supreme Court is just not going to be able to correct. And so it is important to remember our system, as much as the Supreme Court is at the center of the news coverage, there are many important issues being decided by both state and federal courts all over the country every day. And that's really where justice is made for many litigants. So I do think the founders of the Constitution and of the nation had that in mind in placing the court in kind of a supervisory authority. There are, I should mention though, there is a way that the court has the ability to step in and issue a very quick opinion, which is called a summary reversal. And that is, they're pretty rare. There might be five or so of these opinions a year, but that's a situation where the court looks at what has happened in the courts below and says something has gone so egregiously wrong in terms of outcome for that it feels comfortable summarily resolving the case with just a short opinion and no argument. So these are cases that don't go through that full process I just mentioned. So the summary reversal process and option can be a good mechanism for the court to police more of those kind of cases of injustice or misapplication of the law than it otherwise could if it had to hear every single case and argue on the merits.
If a case has, but any case that's coming to the Supreme Court has already gone through that entire process. They've already gone through all the district courts, the appeal courts, the federal, local, state, federal, within the state or the district, so to speak. So
right.
if they can't get into the Supreme Court, there's no, that's it. That's the final. That's
right.
Correct.
That is right. The Supreme Court is the court of kind of final review. There are situations where the court has not stepped in to police something and people have then pursued. If we're talking about a statute, for example, people will then lobby Congress to say, okay, the Supreme Court hasn't fixed this. Why do, Congress needs to fix this confusing language in the statute, for example. So there are other mechanisms in the process, I guess, to try to draw attention to and fix injustices or things that are confusing about the law. But yes, you're right. For the most part, if you've gone through the federal appeals system and the Supreme Court doesn't hear your case, that often is the end of the road for your particular matter.
Can you go back the next year?
You can't unless you have a new action and a new case where you have standing to pursue. There are ways, if you're a prisoner, for example, and say new evidence comes to light that shows you were wrongly imprisoned, there are procedures and ways to try to start a new case to bring all that to light. And many of those cases do end up making it before the Supreme Court, and both in the context of hearing emergency cases relating to people's sentences or executions, but also people trying to assert what's known as their right of habeas corpus, which means they need to be released from prison because there's been, say a grave constitutional violation or new evidence that no one was aware of at the time of the conviction, things like that.
So in order to put it back in front of the court the next year, you have to have a different tact toward it.
Generally speaking, that's true. There are rare instances where you can seek rehearing from the court and you can say, you got this wrong, please rehear my case. That is, to say it's rare is really an understatement. The court generally does not hear petitions for rehearing. But
I'm talking about if you never actually get your case heard, if they don't pick you as one of the 60.
Oh, I'm sorry. If they don't pick you, the formal thing that happens is the decision below becomes the final judgment in your case.
So if you presented your case and then they don't take it, to go back the next year, you can't do that unless you have new evidence with the case or something of that nature. Okay,
that's right.
Well, for my last 2 minutes here, I love our new schedule here. Imagine how America would lack justice for us if we did not have a Supreme Court.
Well, I think, without the Supreme Court, we would have the situation I mentioned before where your justice would turn on individual judges and where you live instead of what is the correct interpretation of the federal constitution or constitutional principles or statutory law. So if you think about it, you could be without a Supreme Court that's able to, and I should say, this goes for all courts as well, but if we're thinking about the Supreme Court in particular, without a Supreme Court kind of sitting atop the system and really having a landscape view of everything that's going on in the lower courts, the trends, the decisions that are contradicting each other. If there were no one to step in and correct that, then you would have a situation where, you could be doing something lawfully where I live in Tennessee and drive next door to Alabama. And the same thing would be held unconstitutional under the federal constitution. Now, that's not to say that type of difference isn't a very key part of our system when we're talking about federalism and states' rights, and states are able to experiment with different laws and policies. But when it comes to the federal constitution, the thing that we are all bound by, there's, and federal law, which we are all bound by, there is a sense that it would be highly unfair if those laws meant something different, depending on where you lived or which judge you happen to have your case before. So the Supreme Court can really play a key role in fixing those types of injustices across the system.
And also, I think in closing here, for my segment, the states, you wouldn't have the arguments. There wouldn't be anybody to arbitrate between the states, correct?
That's absolutely right. There are very important, cases about and river rights to, who owns the Colorado River, where does their boundaries stop? So there would be, it'd be very difficult to arbitrate between state levels disputes between the states. I think that's a great point.
Yeah, that's because right. where would we go then? Okay, right. Thank you so much. It's my 10 minutes, and I'm going to toss to Tova.
Hi, thank you so much for being with us. I wanted to ask a bit about the clerk system in general. How did that system develop throughout American history? Have there been clerks for as long as there's been a Supreme Court? And also, how does clerking for a Supreme Court justice compare to the role of a clerk, in federal or lower courts as you've also been?
Great question. So I can't seem to recall exactly when law clerks kind of came into the fold. I do think there was a period where the justices were just doing the work themselves. I think in earlier times, the justice may have one kind of assistant who's both doing administrative tasks and legal research. And that person might also be helping a few other justices at the same time. So I think throughout the middle of the 1900s is when we saw a shift more towards the model of the current system as we know it, where justices will have designated law clerks in chambers. And, being a law clerk is, many people will tell you, just the best job you could imagine. You get to, from a young lawyer's perspective, you get a mentor that will help you with your writing and your research and your thinking skills. From an advocacy perspective, there's something so incredibly valuable about getting to watch oral argument and then immediately go back and listen to your justices or your judges' feedback on what they thought the advocate did well, what they missed the mark on, that you can kind of take those tips as you move forward in practice. In terms of the differences between the lower courts and the Supreme Court, if you're clerking on a trial court, you're going to see you're going to interact with people a lot more. You're going to see criminal defendants in front of you. You're going to see jury trials. You're going to see, prosecutors and defense attorneys, kind of the more human side, I would say, of the justice system. You're making decisions on the fly, often on, very difficult legal issues. So as my old trial judge, Judge Leon, used to say, we're in the trenches doing the real nitty gritty work of the justice system. When you get up to the federal appeals court, where I had the privilege of clerking for then Judge Kavanaugh, it's similar in a lot of ways to the Supreme Court clerkship. I would say the key difference is the role of being able to choose your cases at the Supreme Court. So the discretionary docket on the petition for cert is a very different, both strategic and legal aspect of the clerkship that is not present when you're clerking on the federal courts of appeals, where every case just gets chosen for you and you don't have the ability to select your cases. So I would say those are probably the biggest differences. But generally, you're doing a lot of writing and a lot of research and getting to listen to oral arguments and communicate with your co-clerks about legal issues.
Definitely sounds like a very invigorating job. And I was curious, when you're doing research on behalf of a justice, what tools or resources do you typically rely on? Do you get access to any that, aren't ones that anyone would be able to use? And then I have to ask the classic question about generative AI. With these systems now in place, do you see the role of a clerk shifting when, the more rote tasks like comparing cases might be able to be automated?
That's both awesome questions. As for the research, so the primary pools we're pulling from are, at the Supreme Court, we're very fortunate to have many what are called amicus briefs. So these are briefs where you're getting briefs from the main parties in the case. So, if the case is John Smith versus, Benjamin Button, you're getting briefs from both sides. And then you might have very well-resourced historians and other advocates filing briefs with historical research to shed additional light on the issues that the parties might not have space in their briefs to cover. Or there could be someone who has a historical angle on the case that is new, and that it really would take like a historian to really dig into the research to present. So as a clerk, we're able to draw from all of those briefs before us, and then of course perform our own independent research using, the Supreme Court has a fantastic library with pretty much any resource you could imagine, and a whole staff of incredible librarians who are trained in different areas of historical research that can assist you with these tasks. So that is how we go about kind of researching founding era documents, or, you know, the Federalist Papers, or Farron's records from the state conventions, old cases, old briefs are all at our disposal. I think it's trickier when you're at the federal, other lower federal courts that might not have those materials to access quite as readily, but there is a trend towards advocates paying more attention to that type of historical research and presenting it in their briefs. Oh, and then the AI, I don't want to leave the AI question out. So I think AI, I still am on the very cautious train on the AI front. You know, I think the thing that makes lawyers not robots is that every case presents raises what is the next case going to be, and what are the edge facts and the edge cases that are in the gray areas of what a case might say. And so I think it's very difficult for AI to really operate in those gray areas where you need excellent lawyers to reason by analogy and to figure out, okay, this case says you can't do X, but what if I, you know, just tweak the facts a tiny bit? Can I still do X minus 1? And I think lawyers are going to have quite just an ever-present role to play, because by the time you get to the Supreme Court, the issues are sufficiently difficult and complex where, you know, you're not going to be able to feed in 2 briefs and say, what's the right answer? There are, you know, there's many different methodologies for how to get to what the right answer might be in a case. So I would still say, still go to law school if that's what you want to do. You're not going to be replaced by AI.
That's good to know. And then I wanted to ask on a more personal level, as a clerk to a Supreme Court justice, what sort of relationship do you get to build with the person you're staffing? And then just personally, what was the most surprising thing about working in the Supreme Court for you that you might not have expected before?
So I think each relationship that I have with my former bosses is unique and very special. As you can draw different qualities and things to admire from each person that you work for. And I totally found that to be true with all of my former bosses. When you're thinking about who you would like to clerk for or clerkship applications, I do think, you know, some people are drawn to certain areas of law or certain geographies, but one thing to really think about is, does this person have a reputation for being a mentor? And, you know, it was extremely special. And does this person have personal qualities or commonalities with me that might make us a good match? So, you know, my last clerkship with Justice Barrett, I, at that point, had children, and she was also, you know, had children. And so we got to bond over that, being kind of working mom, lawyers. So that was a special relationship. So every boss is special. And then I would say the most surprising thing to me was just how close of a community everyone at the court is. The clerks, you know, you can often get a picture of the court as being bitterly divided. And certainly there are cases that cause controversy, but every person, every clerk, staff member, justice walks around and kind of is friendly and knows each other and works together. And so that was, you know, surprising to me, and surprising in a very pleasant way.
Well, that's great. Thank you so much for sharing, and I'll now pass on to Jewel and Jordan.
Hello. Thank you so much for the show so far. One thing that I thought was just an interesting aspect is, did you ever find yourself picking different cases based on what Supreme Court justice you were working under? Like, what interested them more?
When you're talking about what cases you might want to choose to hear on the merits or work on, or both, I guess. Yeah, you know, the dynamics of what cases to select to hear on the merits is a real fascinating one. Different justices have different perspectives on the cases that they might be looking for. I think we're all human and we all gravitate towards things we might have encountered in previous practice or encountered in the real world. So I think, one important part of being a law clerk at the start is getting up to speed on what your justice has written in the different areas of law, because sometimes the justices will write opinions when they choose not to hear a case. They might publish a short opinion with that decision saying, you know what, this is not the right case for us, but I'm really interested in eventually hearing a case that raises this particular legal issue. So as a law clerk, it's important to kind of have that library in your mind so that when you're culling through the thousands of cert petitions you get and you come across one that raises that issue, you're like, I remember, my boss wrote something about this 6 years ago or whatnot. So you definitely want to have that in mind. And then different justices have different philosophies about the types of cases they think are most important to take, and have written about that. And I've written, that Justice Kavanaugh has said publicly he thinks the court should take more cases and take more cases that raise kind of federal splits in authority. So I would say as a clerk, it's very important to know your boss's preferences and to try to carry those out as you're doing the job on the cert work.
Gotcha. Another question is, when I got a little confused about the order when you're talking about the process of the Supreme Court, when you're picking, when the majority opinion is assigned and the minority opinion is assigned, are those assigned before the decision is made, and then those arguments are then brought to the discussion of the actual, let's call it trial, or are those decided after the final decision is made, and then that's just written for the public to view?
So it is a confusing process, but so the order is, the first thing you're going to do is you're going to hear argument, and then pretty soon after argument in the case occurs, the justices will meet and they will each vote on how they think the case should come out. So say you get into the conference room and 7 justices vote to uphold the law and 2 justices vote to strike down the law. The senior most justice in that 7, so the majority, will then assign who is going to write the opinion for the court. And so it's a vote pending kind of the drafting of the opinion, which the opinion, when the decision is not final and there's no final word or vote until that opinion is published to the public. So there is a lag time between when the justices vote at conference and when the opinion finally comes out. And that lag time could be, 6 months, it could be substantial. During that time, you have the majority author circulate a draft to the other justices that they can react to. They can ask for changes. They can say, you know what, and this does happen, they can say, I actually changed my mind. I'm going to vote with those other 2 who voted, to strike down the law. And so after that majority opinion circulates, there's then some time for the dissenting justices to write a draft dissenting opinion. And then the drafters go back and forth responding to each other, as you maybe have seen in Supreme Court opinions. They'll say the dissent says this, and the dissent will say, well, the majority is wrong. So all of that plays out over the span of months. And then finally, when it's ready, the opinion comes out for the public, and that is the binding decision of the court that disposes of the case. So does that help clear up a bit how the process goes? Yeah,
that made it super clear. Thank you.
Of course.
It's amazing how much the clerks really do. The title clerk doesn't quite sound like what it really is. Do you think that it's that there's any positive aspects that the general public doesn't understand, how really integral or powerful what the clerks are doing is? Or do you think that would help more for people to understand how that part of the courts work? Or does it keep it from those positions too becoming politicized the way that our justices are?
I think it's probably for the best that the clerks play more of a background role. At the end of the day, the justices are the ones with the commission from the president and the authority from, Senate confirmation under the Constitution. So I think any time a clerk gets in his or her head that they're more important than they are and operating on the level of a justice is not the right frame of mind to be in. But I do think, the public would be interested and probably heartened to know that there's not just one justice, but a team of, hardworking young lawyers around that person, and people who have different life perspectives and different experiences that can add to the dialogue. And I think there were many times when my co-clerks and I would disagree about a case, and the justice would sit and let us have at it and argue it back and forth. And, there's that saying, iron sharpens iron. And that's kind of the premise of our adversarial system, is when you pit two sides against each other, the right answer is going to come out through that process. And so I think it is important to keep in mind that process is playing out in every chambers, where you have people taking different positions and really trying to get to the right answer, and bring all of the differing perspectives and counter arguments to the table to make sure they're dealt with.
Wow. When you were talking about the memos and how it can be a lot of pressure, this may put you on the spot, but without talking about particulars in a case where you can't speak of, is there anything that comes to mind of high pressure situations like that you can remember having to get something in and being nervous or just really concerned about it?
Yeah, absolutely. I mean, this is every time we would publish something to the public that had, the justice's name on it, I would have a pit in my stomach thinking that I double proofread and triple proofread. So it's very nerve-wracking. The most difficult aspect of the job oftentimes is dealing when you're talking about the emergency cases or death penalty cases. And the court, it is just part of its job to deal with those cases. And so, I mean, when you're talking about someone's liberty or life, it is the stake. To say that the stakes are high, is just not even close to putting it how important it is. So I think you just have to. That's why these are 1-year jobs, right? You put it all out there on the field for 1 year. You don't sleep, you don't take vacations, and you get it done because there are so many people relying on you to do all that you can to help the justice make the best decision he or she can.
Thank you so much. This was a really cool show because I think that many of us have an idea about the way our government works, but we have not ever been able to ask these questions or understand this important part of our justice system. We have some audience questions, I believe, that are piling up that we can get to.
Yes. Well, before I get to audience questions, I wanted to quickly acknowledge some students who are with us today, because we always love to have students on and like to give them a little shout out. So we have Sam Crutchfield from Stonewall Elementary, Fred Pursley from Mansfield Classical Academy with 6 students on, Hope Mucklow, a regular on our program, homeschool high schooler, D'Angela Hines from Emerald Coast Christian Academy. Welcome to all of you. We always love having students on. And then for our first question, I wanted to ask one that was sent in by Teresa Speak. And she was asking about the idea of expanding the Supreme Court and adding more justices. And specifically, if you've heard of or are aware of the Keep 9 Amendment to, stop court packing. and keep the number of justices at 9. So feel free, you don't have to say your personal opinion if you don't feel comfortable, but just your like general perspective on this issue as someone who's clerked at the Supreme Court.
Yeah, I will just say that there are, I'll just kind of report the arguments on both sides and let all of you all very intelligent people, make your own pros and cons of them. One argument on one side in pro expansion is that the Constitution, surprisingly actually does not specify the number of justices that need to be on the Supreme Court. Article 3 only designates that there shall be one, Supreme Court. And there weren't kind of statutory designations for the number of justices, I believe, until around the mid 1800s. So from one perspective, the Constitution left this to the legislative process to figure out how many justices would be an ideal number. On the other side, there's the argument that anything that is changing or altering the work of the court or the composition of the court based on disagreement with the outcomes of cases would contribute to having the justices be seen more as kind of political appointee type actors instead of neutral judges, which could, further undermine the court's legitimacy and ability to neutrally arbitrate disputes. So those are the arguments on both sides. I will say from a personal level, thinking about 70 clerks on the court, it would make the hallways pretty crowded in the current building. So that's pretty much, I don't want to say too much more about that. It is a very controversial topic. But I would say those are my kind of understandings of both sides' arguments on that front.
Well, great. Thank you for that overview. And then also before I ask our next question, I want to give a shout out to all of our listeners on Las Vegas, KKVV 1060 AM. They air our podcasts Monday nights at 6 p.m. Pacific. So we always like to give them a shout out as well. And then for the next question, I kind of wanted to combine two audience questions we got. So Mary Jo Smith asked about the process of becoming a SCOTUS law clerk. And also JT Shim asked a question, which I'm also curious about, which is, how many clerks have done, 3 clerkships with Supreme Court justices? I know 2 are actively on the Supreme Court, but is that common for someone to get to clerk for multiple justices?
I'll start with the second question. I would say, no, it's not all that common. But there has been a practice in recent years of new justices hiring former SCOTUS clerks during their first few terms just to help them hit the ground running. And it's very, so that was my experience being with Justice Barrett during her first term. And I know Justice Jackson hired two former SCOTUS clerks for her first term, and Justice Kagan did the same thing. So there are kind of a I guess group of people out there who have had the privilege of clerking for multiple justices. I just happen to have lightning strike 3 times with getting my clerkship. So it's been nothing I could have ever expected. And the process of becoming a SCOTUS clerk begins with, really in kind of high school, law school, college, trying to get, your grades in order and interests in the law. Although I will say, I am not the one that, got into every law school that I applied to and did not go to one of the top 5 schools that typically feeds clerks to the court. So I will say, if you find yourself at a school that doesn't have a huge track record of sending clerks to the court, don't let that discourage you, because it can happen, and I am proof of that. The process beyond that is, doing well in law school, what you would expect, but then also clerking on a lower federal court or a lower state Supreme Court. Both of those provide you the training, and oftentimes your lower court judges will have relationships with the Supreme Court justices and can recommend you and recommend your work product to them. And that was the case with me. And I had professor recommenders and my lower court judges who were able to put in a good word for me with my first Supreme Court boss, Justice Alito. So that's typically how the hiring process works.
Makes sense. And what an accomplishment to get to work for multiple. And then Grant Anderson asked, does the Supreme Court ever weigh in on class action lawsuits, especially as it pertains to restrictions of constitutional rights like freedom of speech, Second Amendment, etc., where the legislative branch may have overstepped their bounds?
Yeah, absolutely. The Supreme Court has heard a number of class action cases in the past few years, both raising the question about like procedurally, how do class actions get certified and grouped together, and what are the rules that govern class actions? And just for anyone listening, a class action is basically, you don't only have one person bringing a suit, you have one person bringing a suit on behalf of, say, 10,000 people who are like that person and can form a class of people. And the theory is that when you're able to group together large numbers of plaintiffs, you can bring cases that, because you're looking at, rewards that are 10,000 times higher than just the reward the one person would be able to get if he or she were to bring the case alone. So the court has heard several class action suits. I was clerking during the last in October term 2021, they decided a case called TransUnion, and that was a class action lawsuit deciding the types of cases Congress can allow courts to hear and what type of standing you need to show to be able to bring your lawsuit under a particular, I believe it was a kind of credit repair fair debt practices act statute. So yes, if you're into class actions, the court is a good place to keep your eye on, and the law is they have just granted cert to hear a case that is a class action kind of bankruptcy type proceeding that will have implications for class action. So keep your eye on that one if you're into that.
Will do. And then also I wanted to highlight that JT Shim, with regards to the question about when the first clerk was, did a little research for us and said 1882 was the year of the first clerk. So very interesting.
Okay. Thank you for that research.
Right. And then Mary Jo Smith asked another question about if you could share example cases that SCOTUS has reversed itself over the period of US history, and cases that maybe aren't popular that most people might not know about.
Oh man, that's interesting. I would need to go and look at they've overruled, so reversed itself, there is another word for that, is overruling precedent. And the court has overruled precedent throughout its history, as early as, very early on, it was overruling its own cases. But some recent ones that you might not have heard of, the court overruled itself in a case where it decided an issue of whether states can be sued by other states in state court. So that was not one of the hot button reversals. And then there's everyone is aware of the kind of recent opinions in the affirmative action and the abortion context that involved overruling opinions. But I do think it is important to note that there are many important cases, that we think about as, say, in the 1960s or 70s in the criminal procedure land, where you're talking about rights of attorneys and whether the Fourth Amendment applies in state prosecutions, that involved the court overturning precedent. And, of course, Brown versus Board of Education was overturning Plessy precedent. So it has occurred throughout history. It's typically rare. And there are guardrails on when a court can overrule precedent. But I would just caution everyone to keep in mind that it is not just a recent phenomenon, but it has been occurring throughout, and the different justices have different philosophies on when that is appropriate.
Got it. And then I was curious about the role of public opinion on Supreme Court justice, the workings of the Supreme Court. Just in your experience, to what extent have you seen public opinion maybe affecting directions to take a case in? Or do you think the standard is very much just Constitution and public opinion doesn't really affect anything?
I think, you know, where you might see public opinion coming into the fore is when you're talking about the discretionary cert docket. You could have a situation where you think it's just not the right time to choose to take a certain issue. And there are differing philosophies on that. I think as a general matter, the court has, you know, and Justice Alito has written this in the recent opinion, saying that the court really, you know, in his view, should not be paying attention to public opinion and should be carrying out the Constitution, even if there's public backlash. And, you know, many argue that that is why Article 3 insulates judges from removal, except through impeachment, and insulates them from the political process, is because we do want judges to be independent from what the public thinks, in a way that, you know, is opposite how we think about legislatures and the president's public accountability. So, you know, I think it's dangerous to want to categorize any justice that you disagree with as either being swayed by public opinion or, you know, being activist. But I would, as having been inside the court and seeing how people operate, really say, to the extent we're seeing disagreements, I do truly believe it's on account of differences in interpretive methodologies and ways of looking at the Constitution and statutes and how to get to the right answers. And so that is just a function of having judges from different kind of walks of life and judicial philosophies working together to reach an outcome.
Right. And then Carol Friedman asked another question about the role of a clerk, which is, how long does a clerk serve? What's typical? Is there a certain term, or, you know, what's the average amount?
So at the Supreme Court, the norm is that the clerks serve for a one-year term that usually starts somewhere in July and ends the next July. On the lower courts, there are both state Supreme Court judges and district courts and federal circuit courts that you'll see either career clerk, so clerk, that can be your permanent job, is to be a career law clerk, or you'll have an extended term, like say of 2 to 3 years. That's more common, but in the Supreme Court context, the one-year term is typical.
And what's the typical age of a Supreme Court clerk, or is there no typical?
You know, I haven't looked at that recently. There was some scholarship to suggest that the clerks are getting a little bit older on average because justices are hiring more and more clerks that have more than one lower court clerkship. And certainly, I think some justices, like Justice Gorsuch, has hired older law clerks who are, you know, well on their years in tenure at professorships, things like that. So I do think it differs, but generally I have seen data, or I've seen coverage to suggest the clerks are getting a little bit older than they used to be. But I would still say late 20s, early 30s, probably the norm.
Got it. Well, that brings us to the end of our time. I just wanted to say thank you on behalf of Constituting America for being with us. This was really a treat to get a look into how the Supreme Court works from someone who's had so much experience with it. And thank you to everyone who watched and wrote in your questions. It was amazing to see the active engagement we got today. Thank you to Jewel and Jorn and Janine and Kathy and Lacey and everyone for being on. And have a wonderful day and tune in next week. Thank you.
Thanks so much.